Mr. Tucker, are you available to have a quick conversation at this stage?
Morning, Paul. Your microphone appears to be on.
Thanks, Hugh.
Good morning.
Morning, sir.
Morning, sir.
10 o'clock and the inquiry is resumed. This inquiry relates to the appeal made by David Wilson Holmes and Anthony Raymond Shuttlewood against the decision of Charnwood Borough Council to refuse an application for 170 dwellings at land to the east of Cossington Road in Sileby. This is day 6 of the inquiry, and as usual, please ensure mobile phones and other devices not in use for this event are switched to silent. And unless you're speaking, please, or one of the advocates, please switch off your video and your microphone. As we know, we've run through a number of things on previous days, heard from interested parties, had question and answer sessions, heard from expert witnesses and others through roundtable discussions on education, conditions and obligation. And we've heard from most of the parties' witnesses to do with landscape and planning. Today, the intention is to complete the evidence of the final witness, the appellant's planning witness, Ms Medley. We'll be starting the cross-examination of her shortly. Likely to only need to sit for the morning, but I think we'll take a view on that in a moment. Obviously, if we need to take a break, then we will do. But I don't anticipate we'll be sitting into the afternoon today, but we'll see how we go. Before we do, just to do an update on documents that have been received since we adjourned yesterday. The open spaces strategy, which the council sent through, I've had a review of that and I'm satisfied I have sufficient information relating to those matters in the 106. So I'm happy to leave it there unless there's anything else from anyone on that point. And that can be added as inquiry document 19. That would be great. Thank you. Then received overnight the statement on housing land supply from the council, dated the 27th of April, with an approximate updated position. I appreciate it's not a final statement because that's still to be published. Anything, Mr. Richards, you want to say on that at all?
No, sir. You will have noted that the forecast is for a drop in one decimal place rather than one centennial place. But so far as we're concerned, it doesn't make a material difference to the exercise which you have to undertake.
Okay, thank you for that. Mr. Tucker, any comments?
I agree with my learned friend and have nothing to add, sir.
Okay, I think we can probably then safely leave it there. And thank you for that. If we can add it as inquiry document 20, please, that would be great. Thank you. And then the other things I've received overnight this morning, first thing this morning, is a copy of the CCG's letter of the 27th of April regarding factual points of clarification, and I've received the appellant's rebuttal to that letter. Oddly, I've received it in the wrong order, if you like. I had the rebuttal before the letter, but that's how these things happen. I don't think we clarified exactly how that was going to be happening behind the scenes. So anyway, I have a copy of both letters, which is the most important thing. I don't know whether the CCG has seen a copy of the appellant's response. That's not clear. Ms Shuttlewood, do you know? No, we haven't.
If we could have that would be really helpful.
Yes, if someone from the council or the appellant could forward that, please. I've not had, because of the only receiving the CCG's letter about 15 minutes ago, I've not had a chance to properly digest and think about the content and what we do. I suggest we probably let's proceed with the cross-examination of Ms Medley. I don't think anything in the CCG letter or the rebuttal affects her cross-examination. So maybe if we if we have a break at the end of the cross-examination, or even at the end of the, depending on how fast we get through things at the end of re-examination, maybe have an adjournment and then come back to sort of discuss, you know, what we're doing. And if there's any questions I have, then I obviously see Ms Shuttlewood's around. Are you around, Ms Shuttlewood, later on this morning and early afternoon if needed?
I am anytime today. If you need me, just can you ask someone to email me or ring me?
Yes, I'm sure.
Shall I put my details in the chat? Is that acceptable?
You can do, or do you have contact details for anybody in the council who you can email that to, like Ms Knott or?
Yes, I'll find that out. I'll find that out.
Okay, well, Helen can get in touch with you. Ms Knott can get in touch with you if that's easy. I mean, you can use the chat, but we tend not to use the chat because it's distracting.
No, you don't want to get it clogged up. Okay, no, that's really helpful. Thank you.
Yes, we'll make sure you sort of are told what's happening. And likewise, Mr Hunter, is he around if needed, Mr Tucker?
I certainly hadn't anticipated him being in attendance for a formal session, but I'll make inquiries and perhaps we can report back at the mid-morning break. I had thought that the document had been sent to the CCG. I know it's been sent to the case officer. There's certainly no discourtesy intended in relation to that, and we'll make sure that's done immediately, or rather others on the call will hear that, and I'm sure it will be sent.
Sure, no, it's fine. I think that as long as everyone has it, that's the main thing. As I say, I'll take stock during the break and then come back to confirm what we're doing. And it may be that there is no further discussion needed, but I just need to have a little bit of time just to think it through.
In the meantime,
yes, Mr. Richards.
In the meantime, do you want us to upload those two documents?
Yes, I don't think there's any concern about accepting them and having them as inquiry documents. So yes, the CCG's letter can go on as ID 21 and the rebuttal as ID 22. I assume, Mr. Richards, obviously, as yesterday, you're not seeking to contribute anything from the council's perspective to this.
No.
That's fine.
Other than perhaps a sentence in closing.
Okay. Well, of course. Well, that's obviously that's you have that opportunity should you wish. Okay. Fine.
So, yes, sir. Just to confirm for your comfort, I intend to be about an hour and a bit probably, okay. And then I think that the third parties may have some questions for Ms Medley. So I think your optimism about the timetable for today is well founded.
Okay. Well, we'll see. I think we certainly will have a break if just nothing else for me to consider the CCG letter and response. So we'll see how we go. But if there's anything else from you, Mr. Richards, from the council's perspective?
I don't think so, sir. Thank you.
Okay, Mr. Tucker, anything from your side?
No, sir. There's nothing from me. Thank you.
Okay. And anything from any interested parties at this point? I'm not aware of anybody wanting to speak who hasn't already spoken. As Mr. Richards has pointed out, obviously questions from Ms Medley can be put to her at the end of the cross-examination, but we'll obviously see how we go. Okay, if there's nothing else from anybody, then hopefully Ms Medley is ready to go, and Mr. Richards, you are too.
Yes, sir.
Okay, well, hi, Ms Medley.
Good morning, sir.
Okay, well, Mr. Richards, when you're ready, please begin.
Thank you very much. Yes, good morning, Ms Medley, from me too. What I'd like to do in order to try to assist the inspector is to conduct this cross-examination under the headings of the main issues that he identified. And the first one we can be very brief on. That's to say the effect of the proposed development on the character and appearance of the area in relation to landscape and the area of local separation, because as we've already identified, that was the issue between Mr Cook and Mr Higson. And you confirmed yesterday in evidence in chief that your case is that if Mr Cook is right, I think that was the way it was put, then planning permission ought to be granted. And then you were asked if Mr Higson's right, and then there was a long pause, before you eventually had the courage to say that planning permission ought to be refused.
That's correct, yes.
Yeah. But of course, insofar as the inspector might be assisted by either Mr. Cook or Mr. Higson, because we know that the inspectors had a site visit himself, there's also the assistance to be gained potentially from Messrs. Gulby and Luck, who submitted the LVIA with the original planning application.
Yes,
That's right, isn't it?
That's correct.
Yeah, and I suppose it's fair to characterise Gulby and Luck as sitting somewhere in between Mr. Cook and Mr. Higson.
Yes, I would agree.
Gulby and Luck identified adverse impacts, but not of the magnitude and significance that Mr. Higson does. But also Gulby and Luck said that they thought there was a strategy to minimise the adverse impacts.
Yes, I agree with that.
Okay. All right. So I think that's all I want to deal with under that first main issue. So if we proceed now then to the next main issue, which is whether the proposed development would be in a suitable location, having regard to the development plan and national policies.
Yes.
And conventionally, we'd start with the development plan, and as we discussed yesterday, the core strategy, CD 6.03, is the most recently adopted part of the development plan so far as Charnwood Council is concerned. We'll come back to the neighbourhood plan, which of course is also part of the development plan. But and then can we go to CS1, please, which is on page 30 if you're looking at it on paper, or page 31 if you're looking at it in the PDF version on a screen.
Yes.
And we saw yesterday the hierarchy of settlements, and where service centres on the second page of the policy fit in, including Sileby.
Yeah. Yes.
Sileby as a service centre, and that service, we know, don't we, if we look at the neighbourhood plan, the adopted neighbourhood plan, which is CD 6.13, and if we go to page 27, we can see a description of Sileby and the part that it's played in delivering housing development on behalf of itself and on behalf of the borough. So that, for example, on page 27, we can see in the fourth paragraph up from the bottom of the page, 2011 census data showing Sileby population of 7835 residents, 4.7% of Charnwood. Population had increased in the 16 years since the previous census in 1995, along with a 5% growth of the total share of Charnwood's population. In 2011, Sileby had a housing stock of 3,319 houses, 4.89%, and so on and so forth. So it's perfectly plain, isn't it, that over many years, that Sileby has grown.
Yes.
It was planned to grow further in the current adopted plan, and it's planned to grow further still in the emerging local plan.
Yes.
Yeah. And and if we look on the policies map of the emerging local plan 6.05, CD 6.05.
Yes.
That illustrates the direction of the most recent growth through the areas of white land to the northeast and to the east, and then the orange areas proposed allocations, which we know from ID4 are either largely under construction or subject to a resolution to grant. That indicates the direction of future growth.
As it currently stands in a
as it currently stands,
unexamined plan, yes.
And as was referred to yesterday in Mr. Gould's evidence, we can see that so far as growth is concerned, Sileby is constrained by various matters, including the floodplain to the west, which we know gives rise to a constraint under national planning policy.
Yes.
And then to the north and south of Sileby, there's a local policy constraint, which we'll come to shortly, I do promise you, in terms of areas of local separation.
There are, yes.
Yeah. So in other words, growth of Sileby to the east and the west is very much as one would expect and logical. Sorry, to the northeast and east is very much as one would expect and is logical.
Insofar as the floodplain to the west, I'd agree. In terms of the ALS, I wouldn't necessarily agree. I think you'd need to take each development proposal on its own merits and look at the sustainable location of the development.
Yeah. Yes, that's quite right. We're going to look at that in a minute. But as a matter of principle, if one was asking oneself, well, why hasn't there been more growth to the north and south and west of Sileby? The answer is obvious. It's because it's constrained.
Largely, it may be other reasons that land hasn't been brought forward for land ownership reasons. I couldn't comment on each individual land parcel.
Let's then look at back to CS1 again, if you could, in CD 6.03 on page 31 or 32, depending on which way you're looking at it. We can see from the third bullet point, can't we, that service centres will play their part by responding positively to sustainable development.
Yes.
So that's an indication. So that's an indication that a judgment as to whether or not a proposal is sustainable development will be necessary in applying this policy in a development management context.
Yes.
Yeah. And then lastly, that third bullet point refers to responding positively to development which is in accordance with the policies in this strategy.
That's what it reads, yes.
Yeah, and in other words, one has to take a view, no doubt you would say overall, whether or not the policies in the strategy were supportive of the development.
Yes, clearly the plan as a whole hasn't delivered what it was anticipated in the urban areas, the sustainable urban extensions, and service centres have been able to accommodate further growth than originally anticipated.
Indeed,
It's a ceiling.
Indeed, they have. So you would say, and I think I'll paraphrase what you've just said, I think fairly, you would say that one of the policies in the strategy that you would want to have regard to would be the policies that dealt with delivering the need for housing, meeting the need for housing.
Yes.
Yeah. But there are other policies that you would have regard to. Environmental policies like floodplain and triple SI, and also the policy CS11. That would be a policy which deals with the areas of local separation, which I want to move to now. But that would be a policy to which you would have regard to in reaching your overall judgment under policy CS1.
Yes. But the ALS is a tool, a planning tool, and it needs to be balanced with the need to deliver housing.
Yeah, absolutely. As I think we will see together now when we go and look at CS11, which, if memory serves me correctly, is on page 68 of the paper document and 69 of the PDF file.
Yes.
This plan is set out, as so many are, with a sort of introduction to the policy, and then the policy comes after the supporting text, doesn't it?
Right.
So if we want to read the background to the policy, we need to go to the text above, and so far as areas of local separation are concerned, I think starting to look at paragraph 7.13 is probably where we ought to start. Our towns and villages are concentrated along the river valleys of the Soar and the Reek and around the edge of Leicester. As these towns and villages have grown, the space between them has got smaller because of this landscape. Our communities have increasingly become concerned about their identities as separate places. Areas of local separation have been used successfully to guide development in areas between our towns and villages. The policy has maintained the character and identity of individual settlements and prevented their coalescence. So that's a good potted history and summary of the purpose of the policy, isn't it?
It is, yes.
Yeah. And it notes in particular that this is not a recent invention, but is a long-standing, as both you and Mr. Cook acknowledge in your proofs, which the inspector will have read, a long-standing policy tool in Leicestershire.
That's correct, yes.
Yeah.
The defined ALS areas were set out in the 2004 local plan.
Yes, indeed they were. But they predate, but the concept of areas of local separation predates the adopted, the 2004 local plan, doesn't it?
The concept does, yes.
Yeah. And then, as you quite rightly identified not long ago, paragraph 715, the retention of areas of local separation will be balanced against the needs to provide new development, including new homes in the most sustainable locations.
Yes.
And that it is a matter which has been acknowledged in the emerging local plan too, hasn't it?
To an extent.
Yeah. In other words, the use of areas of local separation and balancing them against the need to provide new development wasn't something that came to an end in this core strategy. The approach persists into the next round of plan making.
It is in the emerging local plan to be continued, rolled forward.
Yes. But the approach of reviewing areas of local separation is also carried forward. Whether you like the outcome of the review or not is a matter for the examination of the plan, but that approach has been carried forward.
Yes, it has, and as we know, the ALSD to which we are referring, it is proposed to extend that to the west of Cossington Road.
Indeed, as the inspector heard from Mr. Cook and Mr. Hickson. And then, as you said yesterday, in fact, the council has, since the adoption of the local plan, granted planning permission for development inside the areas of local separation when it thought it appropriate to do so.
Yes, they've done that on numerous occasions, yes.
Yeah. So let's go then to drop down onto the next page to policy CS11. And of course, this policy was adopted before the arrival of the National Planning Policy Framework, but it is consistent with the framework, isn't it?
The framework being 2012?
Well, no, it is today consistent with the 2021 framework as a principle, that the concept of areas of local separation are consistent with the framework.
Yes, largely I would agree, yes.
Yeah, well, I haven't read anywhere in your evidence that says to our inspector, Mr. Inspector, you shouldn't give weight to CS11 on the basis that it's a policy that's not consistent with the framework.
No.
No. And I think, as we've agreed yesterday, the development management element of the policy is the final 3 lines following the bullet points. But in exercising the development management function, one would have regard to any of the bullet points that are relevant in a particular case.
Yes.
Yeah, and in this case, it's the 3rd bullet point, requiring new development to maintain the separate identities of our towns and villages that are in play, as Mr. Cook and Mr. Hickson have identified and addressed.
Yes, that's correct.
Yeah. And then we know that in the 2004 local plan, and I'm not going to ask you to turn it up, that there is also policy CT4, which deals with development in areas of separation. But do you agree with Mr. Gould yesterday that insofar as there is a difference or a tension between CT4 and CS11, it ought to be resolved in favour of CS11? Absolutely,
it's the successor policy.
Yeah,
I would agree with that.
A bit, and not least because that's what section 38.5 of the 2004 Act tells us to do.
Absolutely, yes.
So that's the area of local separation policy. And when we go to the other part of the adopted development plan, which is the Sileby neighbourhood plan, which is at CD 613.
Yes.
We know it doesn't duplicate the Charnwood policy on areas of local separation.
No, it's not.
But on page 20 of the neighbourhood plan, in the context of the discussion of limits of development, in the 3rd paragraph in that section, we can see a reference there to the risk of loss of separation of hamlets and settlement to the detriment of the community. The matter of separation and community identity, although not subject of a bespoke policy in the neighbourhood plan, is nonetheless referred to in the context of what Charnwood Borough Council have done in the adopted local plan.
Yeah, there's no specific policy.
No, and the obvious conclusion to draw, isn't it, is that the authors of the neighbourhood plan were well aware of the policies in the borough local plan, and were not seeking to add or detract from it.
Yes, I don't know what the authors thought, but that's a reasonable assumption.
Yeah. And so that is all I want to cover with you in terms of national development plan policy, I think. So far as this main issue refers to national policies, we've agreed that areas of local separation are consistent with the NPPF. So far as landscape protection is concerned, I think there's no difference between us. We know that the approach in the NPPF now is to protect landscape in accordance with a hierarchy, in accordance with national designations.
Yes.
Yeah. But no longer to protect the countryside for its own sake.
No.
Yeah. And that was also discussed also with Mr. Higson and Mr. Hook. Now, so far as the emerging Charnwood local plan is concerned, we know that from the statement of common ground at paragraph 50, you just turn that up. This is in a section headed at the top of the page, Emerging Planning Policy.
Yes.
And so, the draft local plan, paragraph 50, has been submitted to the Secretary of State, and it awaits full scrutiny through the examination process. It's therefore agreed that it can only be afforded limited weight as a material consideration in this appeal. That's a reference to the policies in the emerging local plan, isn't it?
It is, yes.
Yeah, and all in the context of the NPPF at paragraph 48, which is where we find the advice local planning authorities may give weight to relevant policies in an emerging plan according to, and then the three well-known matters to consider: the stage of preparation, the extent to which there are unresolved objections, and the degree of consistencies with the policies in the framework.
Yes, and there are significant unresolved objections to those policies.
Indeed. Have your clients submitted any objections to the submission draft?
My clients,
in respect of the appeal site, I should say, not generally.
I haven't done so on behalf of my client. I don't believe we've objected to. I believe we have objected to the ALS designation rolling forward.
Right. Well, that's what I wanted to clear up, whether or not, on behalf of your clients, I think, I mean, our BDW, but also I think the landowner
Yes.
is one of the appellants, so one of your clients too.
Yes.
Is the objection to the principle of ALSs or the extent of the ALS on the southern side of Sileby?
It's the site-specific related in terms of the whole plan and the soundness of it, the housing needs, everything taken into account.
Yes, I mean, we don't need to burden the inspector with the objections, but the matter no doubt is put as a bottom line. The appeal site ought to be allocated.
Yes.
Well, it would be surprising if that hadn't been done, wouldn't it?
Of course.
Yeah. But so as far as the emerging local plan is concerned, this part of the borough at Sileby and Cossington is going to continue to play its part in meeting the need for housing through the plan-led system, isn't it?
There are proposed allocations to both Sileby and Cossington, yes.
Yeah. Now, of course, there are also national policies, including the very important presumption in favour of sustainable development. But that's probably more conveniently dealt with under another main issue. So let's go there. But before we do, can we just very quickly tidy up the position on the inspector's main issue, whether or not the proposed development makes adequate provision for affordable housing and other infrastructure requirements? And I think your short answer to that question is yes.
That is my short answer, yes.
Yeah. And it's common ground for the reasons set out in the statement of common ground. So, for example, on affordable housing, the proposal, subject to the necessary condition, will deliver a policy compliant level of affordable housing.
It will. It's 51.
And all of the other matters will be dealt with, and subject to the inspector resolving the outstanding issues on healthcare and education contributions. The answer will be yes, the development, if granted permission, would make adequate provision. And there are, I think, blue pencil clauses in the section 106, so that depending on which way the inspector resolves the two outstanding issues, what will be provided will be in line with the inspector's findings.
Absolutely correct, yes, and reason for refusal too would fall away in any event. Yes.
Indeed, so I don't think there's anything else for us to discuss under that main issue. So let's move then to the final main issue, which is whether or not any conflict with the development plan and Harmarising is outweighed by other considerations.
Yes.
And that echoes the paragraph 11D test, doesn't it?
It does, yes.
Yeah. And so far as the adverse impacts are concerned, I think there is a measure of common ground, certainly between you and I, for the purposes of this cross-examination. We know that the area of local separation impacts are disputed. We know that the landscape character and appearance impacts are disputed.
Yes.
But we know that the loss of best and most versatile agricultural land adverse impact is not disputed because it's set out in the statement of common ground at paragraph 79.
It is, yes.
Yeah, and I think that those are the that's the extent of the list of adverse impacts.
I believe so, yes.
Yeah, and then again, helpfully, the statement of common ground identifies the benefits. And the provision of both market and affordable housing are individual benefits and acknowledged.
Yes.
And the position of Sileby as a service centre and the facilities within walking and cycling distance from the appeal site. Mr. Gould was concerned yesterday about double counting. And he acknowledges that the primary school is within walking and cycling distance, and says that he wraps that up in his assessment of that benefit without counting it twice. But I don't think the inspector will fall into any double counting trap. However, you've expressed it and split them up in your proof. I mean, you certainly don't want him to double count anything, do you?
Absolutely not. No.
No. Okay. And then the economic and the biodiversity net gain.
Yes.
And then those that are disputed largely as a result of the dispute between Mr. Cook and Mr. Higson.
Yes, I think from the discussion yesterday, it was more about the degree to which the benefit was considered by Mr. Gould, rather than paragraph 93 being the actual benefits of themselves. Yeah.
But insofar as the benefit of providing market housing is concerned, we know, first of all, that it's relevant to consider whether or not the appeal site would be able to contribute to the 5-year housing land supply deficit if granted permission, and it's common ground that it would.
Yes, it would.
Yeah. But it's also relevant, isn't it, for the inspector, when he's carrying out his overall planning balance, to have regard to, well, how long is this undesirable housing land supply shortfall likely to persist for? That's a relevant matter, isn't it?
Well, the position as it stands, as we know from the overnight paper that the council have given, is that the position is 3.23 years, which, yes, 1 decimal point, it has regressed, but the position has been worsening over a number of years. And yes, it is true that the 5-year housing land supply position should, upon adoption of the emerging local plan, be there, but
yes,
we don't know when that will actually be yet.
Well, let me perhaps illustrate this another way. As is quite commonly the case, planning inspectors have to make decisions either towards the end of or very close to the start of the new housing land supply year, which usually runs from 1st of April to 31st of March.
Yes.
And it's not unknown in appeal situations that the next year's figures get published either during an inquiry or even after an inquiry is closed and before a decision letter is issued.
Yes, absolutely.
Yeah. And if the position in Charnwood had been that there was a 5-year housing land supply now, but that it was about to change and dip below 5 years, that would be highly material for the inspector to take into account. And if it was the case now that the supply was below 5 years but was about to go above 5 years, that would also be something for the inspector to take into account.
It's a material consideration.
Yeah, and therefore it's also a material consideration for the inspector to consider and ask himself the question, for how long is it likely that there will not be a 5-year supply at Charnwood?
Yes.
Yeah. And as you just indicated, and as Mr. Gould told us yesterday, the answer to that question is going to be for as long as it takes the borough to adopt the emerging local plan.
Yes.
Yeah. And Mr. Gould noted that according to the council's published local development scheme, that was foreshadowed to be in December this year or January next year, which he had described without further adjectives as optimistic.
Yes.
Yeah.
And I think Mr. Gould settled on something like at best summer next year.
Yes, he did. Yeah. He also accepted, I made a note, that there could be a range of reasonable options on the issue.
Yes, of course.
Yeah. You said in your evidence in chief that you thought that even Mr. Gould's assessment of summer of 2023 was optimistic, but you didn't say when you thought it would be likely to be adopted. And so I just want to explore that with you. We know that the examination is underway and the oral hearings are fixed for June and July.
They are, yes.
Yeah. Do you have any reason to doubt at the moment that something will derail that plan for June and July oral hearings?
I imagine the hearings will go ahead.
Yeah.
As we know, though, the examining inspector has written to the council requiring further information regarding the allocations and the 5-year supply. So there's issues.
And as indicated in the note this morning, the council plans to submit that information to the inspector tomorrow, the examining inspectors tomorrow.
Yes.
And at the same time publish its update on its 5-year housing land supply for development management purposes. So it's doing two things at once. It's doing the assessment of the monitoring year, and it's providing information to the plan inspectors.
That's what the note has said, yes.
Yeah, and for obvious reasons, the data for one will fit into will support the data for the other, and there'll be a commonality of material relied on, no doubt.
Yes.
Yeah. Now, can we agree that after the oral hearing sessions, that it is likely, very likely, that the inspectors will identify main modifications that are necessary in order to make the plan sound?
I think there's a significant likelihood that that will take place and that there'll be significant main modifications.
Yeah, and that therefore those will be required to be consulted on.
Yes.
And then once the inspectors are seized of the responses to that consultation, they will then have to decide whether or not a further round of oral hearings are necessary.
Yes.
Yeah.
Absolutely.
Now, I think it's fair to say that on Mr. Gould's timetable, he was not identifying a timetable for further oral hearings.
No, that's correct.
He was assuming that the inspectors would be able to make any final modifications to the plan as a result of a written main mods process.
That's what I understood to be the case, yes.
Yeah. But I suppose one ought to anticipate, and perhaps you do, a further round of oral hearings to be programmed into the timetable towards adoption. Is that right?
It may be the case, yes. I mean, I'm anticipating that there will be, or there's going to be a large debate regarding the housing need. We've seen that the housing need has actually increased in the 5-year note that we've received overnight, and the significant objections raised on that alone. The low growth scenario that's been taken forward and the insufficient flexibility allowed in that plan to secure the 5-year supply, but also what was referred to as the elephant in the room yesterday, being the Leicester city's unmet needs, which this emerging plan does not make any provision for within it. Rather, it pushes the issue down the line with a review policy requiring a review to be undertaken within 6 months of an agreed statement of common ground between the neighbouring Leicestershire authorities to apportion those unmet needs. So I think that the mechanism for that trigger may well be actually met way ahead of adoption, or even indeed further hearings, requiring further hearing sessions for the appeal.
Okay.
For the examination.
Let's just deconstruct that. I promise you I will come back to Leicester's unmet needs, but let's for the moment ignore those. But on your hypothesis that there may not even be enough sites allocated to meet the needs without the extra needs for Leicester, because there's an argument to be had, I have no doubt, over what the appropriate housing requirement figure should be. And if the inspectors agree to increase that, they will probably say to the council, right, we think there ought to be a main modification to increase the housing requirement figure, and you need to find some more sites in order to meet that additional figure, or to replace sites that the inspector doesn't think are deliverable that the council proposes to allocate. In those circumstances, the council will come forward with the additional sites, and they will be consulted on as part of a main mod. But usually when that happens, if there are objections to those sites, a further round of oral hearings is heard, isn't it, on those new sites? In that scenario, yes. Yeah. Let me suggest to you that if it's necessary to do that, then that is likely to introduce 6 months into the timetable for adoption that isn't there on Mr. Gould's hypothesis. I would think that's a reasonable time frame, so looking towards the end of 2023. Yeah. Okay. So that's very helpful. So we can record, I think, that if further oral hearings are required for whatever reason after a main mods consultation, that will add 6 months to the process. No, thereabouts. Yeah. And now, as I faithfully promised you, I will come back to the question of Leicester's unmet needs and as to what we ought to assume is likely to happen. What we know from the emerging local plan, which is CD 6.04, I think. Yes. And it's policy DS2 on page 32, or 34 of the PDF if you're watching on a screen. Yes. And the text, the supporting text is above the policy box. So you read the introduction and before you get to the policy. And the issue or the policy flags up, first of all, 2.59, long track record of effective joint working. 2.6 2.60, Leicester City Council has identified an unmet need for housing and employment through its draft local plan. Leicester and Leicestershire authorities have engaged in a process of testing reasonable alternatives options for meeting that need. But then 261, along comes the government in December 2020 and says, Leicester, you have the privilege of being one of the 20 cities to have a 35% uplift.
Yes, that happened.
Yeah, and for the local authorities in the housing market area, they look at each other and go, well, we already know Leicester can't meet its needs. Adding a 35% uplift to Leicester just means it won't be able to meet them even more.
Absolutely.
Yeah. And then 2.62, oh, sorry, end of 2.61, the question then for authorities like Charnwood at an advanced stage of preparing their own local plans with their own needs to worry about, as well as unmet need in the housing market area, is, well, what do we do?
Mm-hmm.
Do we delay submitting our plan or not? And we know that the government doesn't like delay, does it? So on the one hand, it's saying to cities like Leicester, you have the privilege of 35% more houses to produce on behalf of the nation. And on the other hand, the government says to all local authorities, please don't delay in bringing forward your local plans for examination.
Correct.
Yeah.
Yes. Yeah. And other authorities, as you said, in Leicestershire are obviously in the same position. However, a number of authorities have made provision within their emerging plans for Leicester's unmet needs, either through higher growth options and reserve sites, or just an increased housing number.
Okay, so now the issue for the examining inspectors will be, is DS2 a sound approach? Yeah.
Yes.
And if they decided that it isn't, then as you identify, there will have to be more sites found. Yeah?
Yes.
So the inspectors will reach a conclusion on the local needs sites, if we can call them that, but will then turn round to Charnwood and say, but you need to find some more.
Yes.
That would delay the adoption of the local plan, wouldn't it? Further, possibly quite considerably.
It may delay. It depends to what degree the apportionment agreed in the statement of common ground is. Yeah,
which we don't know.
We don't know, but we should know in approximately 1 month's time that the statement of common ground is being finalised. We understand that it's going to various committees next month, as early as May. So
okay.
If that is agreed in May, the 6-month trigger in that policy, in emerging policy DS2, will be met way in advance of actually an adoption of this plan.
Yes. In other words, the review would have to commence
prior to the adoption. Yes.
Yeah. Although where the unmet need for Leicester is met would have to be the subject of sustainability appraisal, consultation, and so on and so forth. And therefore, that would be likely to be, if the council, assisted by the examining inspectors, wanted to wrap that all up in this plan, that would involve quite a significant delay to this plan, wouldn't it?
But I think we already said 6 months.
Yeah, but no. We agreed 6 months on any additional sites to meet Leicester's local needs. Depending on the
Charnwood's local needs.
Sorry, Charnwood's local needs. Yeah.
Well, and Leicester's unmet needs.
And Leicester's needs. All right. Well, depending on how much Charnwood's
apportionment. Okay. Yes.
Apportionment is all right. So let's go back to where we started. If we've got Mr. Gould's hypothesis, 12 months adoption from now, in the event that there isn't an oral hearing main mods round. We've got your assessment of 18 months if there is an oral hearing main mods round, and then we've got a potential further delay if the examining inspectors won't allow this plan to proceed unless and until the outstanding need for Leicester is met.
Yes.
Yeah. And let's assume, for the sake of argument, that adds a further 6 months to the process.
I think that could be captured in the same 6 months.
Oh right. Oh okay. Well, that's even more helpful. Thank you, Ms Medley. So the reasonable range of time to adoption that Mr Tucker was exploring with Mr Gould is 12 to 18 months, is it?
18 months.
To adoption of the plan.
I think that towards the end of next year. Yeah.
Yeah. All right. And so therefore that is the period which the inspector will take into account when he's asking himself the question, how long is the unsatisfactory state of affairs of the lack of a 5-year housing land supply likely to persist for?
Yes.
Yeah, the answer is, on Mr Gould's assessment, 12 months, and on your assessment, 18 months.
Yes.
Yeah, okay, that's very helpful. And then he can balance that against any harm that he finds in terms of area of local separation and landscape character and visual impact.
Yes, the limited harm we've identified.
Well, exactly right. Or so that I don't get a WhatsApp message or the significant harm that Mr Higgson's identified.
Yes.
Yeah. Just going to check my WhatsApp message, but I think that's all I need to ask you about. No, there's nothing there, so thank you very much indeed, Ms Smedley.
Thank you.
Thank you, Mr Richards. Are there any questions for Ms Smedley from any interested parties listening? Councillor Jones, your hand's raised.
Yes. Hello, Ms Medley.
Morning, Councillor Jones.
Yes. You mentioned in your yesterday about the green landscape area if this site was approved. Could you tell me, please, if this site is approved and you do indeed develop this green landscape area for the general public of Sileby, I think you mentioned, who would be responsible for the management of that area?
That would be a management company.
And so all the people who buy houses on this development would have a charge for this management of the area? So can you tell me then how you think they would feel if they are paying for the management of the area yet every single person from Sileby and Cossington has the right to use this area.
It's a standard approach to areas of open space in new developments.
I understand that, but are you aware that this standard approach causes lots of problems with new estates and has caused us huge problems in Sileby with local people using the new play areas, etc., etc., and the people who bought the houses having to pay for that privilege?
I'm not aware of specific issues that you were referring to.
I mean, I understand that it's the general pattern of the new developments, but it's something that does cause us locally a lot of problems, just so that you are aware of that.
Okay, thank you.
Thank you very much. I think Councillor Astle is wants to ask a question.
Thank you, Councillor Jones. Did you have any other questions? Or
No, I think Councillor Astle is going to ask questions that I may have asked, and she's more appropriate to ask them about the neighbourhood plan.
Okay, thank you, Councillor Jones. And so, yes, Councillor Astle, if you'd like to ask your question.
Thank you. First of all, I'm sorry for pestering you yesterday. There's something wrong with the Teams meeting. I think I kept flashing up, so apologies. I wasn't aware of that.
It's okay.
Yesterday, you spoke about the limits to development policy for Sileby, and you made reference to that it wasn't in date. Had you referred back to the independent examiner's report on our neighbourhood plan that was published in September in 2019, and the comments by the planning inspector based on the appeal decision for the Barnard's Drive planning application, and his reaction for the limits of development?
I've not read the specifics on the examining report or that decision, no.
In those documents, and I don't know whether they are, because obviously with your decision about and reference to the limits to development being out of date, both those documents refer to the limits to development in our neighbourhood plan policy as being the most up to date.
Well, hold on before we start going down this route. My witness has said that they're not documents that are before the inquiry and that she's not read them in terms of her evidence. So it's not a question that my witness can answer unless the councillor wants to put the documents in which case Ms Smedley would need an opportunity to read those documents before answering questions about them. This is the opportunity for questions, not the opportunity for telling a witness what's in a document that's not currently before the inquiry. So I'm not necessarily objecting if there is a point that's to be made, but it needs to be done properly, if I may.
Okay. I mean, I as I was writing my notes, I was racking my brains to think, did I have a copy of either the examiner's report or the Barnard's Drive decision? And I don't think either are in the court documents library, are they?
No, they're not.
No. So yes, in terms of any questions to Ms Medley, Councillor Astle, it's obviously difficult
Are we going
to answer.
Submit those documents to you?
I suppose if you wanted to ask questions on them, they would have to be submitted. Ms Smedley would have to have the opportunity to consider them, and then obviously you could put your question to her. Mr Tucker, what's your thoughts on that in terms of?
Well, it's obviously slightly unusual to do that at this stage when the core documents have been before in the public domain for some considerable period of time. But that's I don't want you, sir, to be shut out of information that's potentially relevant. And it's not simply looking at the document itself. It's also a matter of making sure that the witness has read around the documents. Mr. Richards has got his hands up.
Yes.
So I do wonder whether the documents are necessary. I think Councillor Astle is indicating that the neighbourhood plan settlement boundaries are the most up-to-date boundaries that there are. I don't think Ms Smedley is disputing that, but I think it's the lack of a 5-year supply that makes those boundaries out of date. which would be the case whether or not the inspector, the examiner had considered them in 2018, 2019, or yesterday.
Yes, I mean, if I can add, with regards to the limits to development of the neighbourhood plan, they're essentially the limits to development of the local plan, 2004, with the addition of the planning permissions that have been granted since that date. So the limits to development essentially were derived from the housing needs in the Leicestershire structure plan, plus the permissions that have, as it suggests, have been granted. The limits to development are not derived from an up-to-date local housing need.
May I come back on that, please?
Yes, Councillor Astle. I mean, obviously, it should be come back in the form of a question rather than your opinion on this. But do you have a follow-up question?
So, in the form of a question, the limits to development policy in the neighbourhood plan document, which does form part of your suite of documents, has details about the housing policy, which is policy, so I'll just go through it, H1 for reserve sites. Have you looked at the background information with those allocations and where that housing need for Sileby has arrived from as being an up-to-date need at the point of the neighbourhood plan being adopted?
Yes, the neighbourhood plan reviewed the 2017 HEDNA data, which was based on a midpoint housing need for Charnwood. The range in the HEDNA was from 8,000 to 15,000 roughly, and a midpoint was taken of 12,000. Then a percentage of population was taken to derive the Sileby needs, which equated to, I believe, 566 dwellings. And given the commitments already at that stage, the neighbourhood plan felt that no further allocations would be required.
So, coming back then, would you agree then that at that point in time, and with agreement from Charnwood, it was agreed that Sileby had taken more than its fair share of housing allocations, and even though it still went on to make some reserve allocations because of that, because it had taken more than already anticipated or felt was appropriate for the size of the village?
Yeah, I appreciate the question. That was the latest data that was available at that point, the 2017 HEDNA, but that's an out-of-date housing figure. The HEDNA was never adopted in any strategic policies by Charnwood, so it was relied on by within the neighbourhood plan. But as Mr. Richards has already just pointed out, the 5-year housing land supply position renders those out of date also.
So, I'm sorry, I'm a bit confused, but the neighbourhood plan had passed the examination and has been passed the referendum, which has made it part of the local development plan. So is that not the most up-to-date policy regarding limits to development for Sileby, even though we've got this position of the lack of housing land supply?
It's more up to date than the 2004 local plan, yes, but it is considered to be out of date.
Thank you.
Thank you. I think yes, thank you. I think that's helpful to hear that discussion. Councillor Astle, are you wanting any other questions or anything else? Obviously, you put the initial question about the examiner's report and the Barnard Drive appeal decision. You've heard the response. Are you still wanting those you still wanted to make points on those, or has that discussion sort of covered what you wanted to cover with Smedley?
Well, would you like us to put those documents in anyway, or not? Or do you not want to see them? They are our information for the parish council's initial response anyway, or there's reference made to them in the parish council responses.
I mean, I suppose, yes, I suppose it's, did you still intend to ask questions on them, or have you put those questions to Ms Medley now effectively?
I think I've put those questions to Ms Medley effectively, thank you.
Okay. Any thoughts, Mr Tucker, on whether they should be added for information or not?
The Barnard's Drive case, I need to read it before I could form a view in relation to that, and I'm happy to take a view to read that over the adjournment that you, sir, are going to have in any event in a few moments. In terms of the examiner's report, I have no objection to you receiving that, sir. I think it's dealt with in about 2 pages under the discussion on policy G1, but it's also summarised in terms of the approach that's taken within the neighbourhood plan itself, and I'll give you the reference when it comes to re-examination. So I've no difficulty in you receiving that part of the examiner's report which relates to the limits of development. It's 2 pages. If I need to come back on anything, sir, I'll do that, having discussed it with Ms Smedley after she's finished her re-examination. I don't think I do, sir, because we've set out our position on the settlement limits in examination in chief anyway.
Okay, thank you. And Mr Richards, any comments on those 2 documents and me having them?
No, sir, I don't think I can usefully add anything. Plainly, the council wouldn't want you not to have something that might be relevant.
Okay. I mean, Councillor Aspel, do you have copies of those, and can you flag up the key sections of both those documents?
I can find them for you reasonably quickly, yes.
Okay, I was wondering whether those get emailed to the council and the appellant, and obviously, yeah, Mr Tucker needs the chance to read both or either, this particular Barnard's Drive decision, then we can obviously factor that into any timings.
Should have the details of the examination, the examiner's report. They should have that quite quickly to hand.
The examiner's report I have, and that can be circulated, but it's readily available on the council's website. I think it would just be a matter of adding it as a hyperlink to the inquiry documents. Really, it's just a page and a half that deals with the limits of development. So it's paragraph 71 onwards, so 71 to 78.
I can give you the appeal reference now. You probably find it quicker than me.
Okay, that might be helpful. Thank you.
Really, and that's APP/X247/W/19/3220699.
Sorry, 3220699.
And it was held on the 6th to the 7th of August 2019.
Okay, and was there a particular section paragraph you were?
It is in paragraph 12 is the main part. It just came out as the examiner's report. It cost, similar to this, it cost over a period, so.
Right, okay.
Examiner's report.
Okay. I mean, Mr Tucker, I don't know, are you able to look that reference up yourself, or do you need?
I'm sure that we have a sufficient team. I'm acting for one of the country's largest house builders and a range of consultants. I'm sure we'll be able to get a copy of that, sir. It may be that we can comment upon that by tomorrow morning after Ms Medley's read it, because one of the things that needs to be checked is whether it's subject to a High Court challenge or not. Who knows? As we sit here today, I don't anticipate it's going to be an issue because, as Mr Richards has rightly said, the settlement back limits are out of date in any event by reason of the lack of a 5-year land supply. There's another reason that I'll explore in re-examination in a moment as well. So I don't anticipate either will cause a difficulty. The only difference is that I've read that part of the neighbourhood plan examiner's report in the last 10 minutes, and I've no objections to that going before you, sir.
Okay. Well, I think then I'm happy to receive both of those documents. But obviously, yes, if there's anything more that needs to be said or a note put in, then let me know. But Councillor Aspel, thank you for bringing that to our attention. Anything else you wanted to say? Question?
No, thank you.
Okay. Well, thank you for that. Are there any other questions for Ms Smedley? If not, then looking at the time, Mr Tucker, do you want to move straight into? We're sort of 10 minutes from where we normally have a break. Do you want to break now, or carry on with re-examination and then break?
I see Councillor Jones has her hand up again, so I don't know if she wants a second go.
Apologies, Councillor Jones, I missed you.
Yes, apologies. I've just looked at my notes and I do have one more question for.
Okay, go ahead.
Okay, thank you. Ms Medley, you mentioned that there was very sustainable public transport which would be available to this development. You mentioned that it's actually Kinch Bus Service 2 that would go past the bottom of the site along Cossington Road. You mentioned it's half hourly. It is at the moment, it's hourly, and Kinch Bus have indicated, because we've had communications with them, that they have no intention in the near future of reverting to half hourly service. So basically, for your notes, it is hourly and is deemed to be continue to be hourly for quite some time. It was obviously to do with the pandemic. Now it's to do with the fact that they don't have enough drivers and there's not enough a number of people using the buses to make it viable, to make it back to half hourly.
I think that's a comment on what's being said. That's not a question, given it's based upon information that my witness doesn't have.
Yeah.
So if there's documentation that substantiates that, again, I probably have absolutely no objection to it going before the inquiry, but I would like to see it before it does. Otherwise, you'll make of that what you will.
Yeah, there is no documentation. It's just inquiries from the Sileby Parish.
Yes, yes. Yes. Was there anything more to your question, Councillor Jones, or did you just want to draw Ms Medley's attention to that?
Draw her attention to that.
Okay, Ms Medley, do you want to say anything in response, or?
I would only say, without having any particular detail on that, I think Councillor Jones has said it's been to do with the pandemic, so I would hope that it would just be a temporary basis.
Okay, thank you.
Okay.
Yep.
Thank you, Councillor Jones. Anything else?
No.
No. Okay. Thank you. Okay, and I should just confirm I don't have any questions for Ms Medley. So, Mr Tucker, did you want to carry out a re-examination now?
Yes, sir. I should take no more than 10 to 15 minutes if you're happy with that.
That's fine, and then we can adjourn to consider the various other things that we've discussed. Yeah. So when you're ready, please begin.
Thank you, sir. Ms Medley, let's do things in reverse order. Adds a free son of excitement to the process. Just on that last point, the issue of buses, if you're able to check that behind the scenes, and if there's any further information you need to bring to the inquiry, if you could do that, that would be splendid.
Yes.
But presumably, do you have any knowledge beyond that which is contained in the statement of common ground at the moment?
I do not.
No. Thank you. In relation to Councillor Astill's questions, you responded by intimating that the neighbourhood development plan was based, at least in part, upon an interesting arithmetic exercise based upon the 2017 HEDNA. Let's just see, just have a look at that so the inspector has the references. So the neighbourhood plan is core document 6.13. And I think my learned friend took you to page 27. Starting on housing in the built environment. Really a matter, forgive me for setting the inspector homework, but the inspector, to understand this section, would need to read 27, 28 and through to, I think, about page 30, just before it says reserved sites, to understand the context. Is that fair?
Yes, I agree with that.
And there's some arithmetic contained on page 29, and you made reference to the 2017 HEDNA, which is a document that we have. I'm happy to say that's core document 6.20. And you told the inquiry that wasn't assessed as part of any strategic document. So let's just look at that. Firstly, the 2017 HEDNA. What weight do you invite the inspector to give to that as an expression of up-to-date needs?
as it hasn't been assessed and doesn't form part of any development plan limited.
Thank you. The needs that are within the 2017 head, no, what do they suggest for the district?
It's just a range of needs. I think page, I think it was the first page, 29. And the range is between 8,100 and 15,700.
Okay. And is that consistent with the LHN, which is now agreed to be the need for the district, upon which the 5-year land supply is based, upon which the emerging local plan is being brought forward?
It's not consistent, no.
That's going to sound like Nikki Campbell now. Higher, lower, or stick?
That is lower. The local housing need is higher. The head no is lower.
Significantly lower?
Significantly lower.
Thank you. So, to what extent are the settlement boundaries of Sileby contained within the neighbourhood development plan consistent or inconsistent with the up-to-date needs as we understand them at this inquiry?
They're inconsistent with the up-to-date local housing needs.
What weight do you invite the inspector to give to any contravention of the settlement boundary, therefore?
Limited.
Good. Next, you had an interesting discussion with my learned friend, speculating about what's going to happen in terms of the local plan.
Yes.
And two different options were put, one of which is that the plan hearings run smoothly. At the end of that, we go straight to main modifications. In one instance, we go to hearings in relation to main mods if new sites are needed. In the other scenario, that there isn't a need for hearings, and that was then put to you as 12 to 18 months.
Yes.
So the dynamic, therefore, being the need for hearings or not, and there was discussion about Leicester, and you said, well, that could be wrapped up in relation to that period of time. I'm not going to go behind that answer. Let's take you to, I'm trying to think of an authority, the Stratford experience, the Warwick experience, the Cheshire East experience. Would it be open to the inspectors on examining the local plan to say that there is a more fundamental problem with the plan which requires more evidence or indeed more work behind the scenes in terms of the plan?
Yes, of course.
Do we have any intimation as to whether that is or isn't something that's likely sitting here today?
As we sit here today, that we know that the examiner has requested further information on sites on the 5-year supply. So, yes.
Well, do we know whether the examiners will send the council off to go and create a new suite of evidence or re-examine other parts of the fundaments of their evidence?
At this stage, we do not.
So let's look at this third scenario then. If the council are sent away with a flea in their ear to go and get some more evidence and review their strategy, would that leave unchanged or extend or reduce the timescales you're talking about with my learned friend?
It would extend.
Significantly or not significantly?
Fairly significantly.
Thank you. And in relation to the confidence of this predictive exercise that we're engaged in, from wholly speculative down to almost certain, whereabouts would you pitch the degree of confidence about when this authority may be able to get a 5-year land supply?
Sorry, could you repeat that, please?
I want to know your degree of confidence, because I have no doubt that we may see within my learned friends closing 12 to 18 months is the agreed period within which the council is going to get a 5-year land supply.
Yes.
We've added an extra dynamic in the last few moments. So I want to know what your degree of confidence in terms of this exercise is. Is this a very confident predictive exercise that you're engaged in saying, yes, 18 months, we may get a 5-year land supply? Or are we the other end of speculative or somewhere in between?
Yeah, completely speculative at this stage. The hearings haven't opened. We don't know how they're going to proceed.
So what weight do you invite the inspector to give to the prospect of there being a 5-year land supply in the near future to resolve the issue, which we now know is going to trip onto another year where the council doesn't have a 5-year land supply? What confidence and what weight?
That very limited weight, limited confidence.
Thank you. And those were only the only questions I had in examination in chief. Thank you very much indeed, Ms Smedley. Thank you, sir.
Thank you.
Spot on 1/2 past.
Thank you, Ms Medley. Thank you, Mr Tucker. Thank you, Ms Medley, for your contributions yesterday and today. So that brings the evidence of the final witness to a close. So in terms of what's left to cover, I think as I indicated at the start this morning, we will adjourn so that I can just go through the CCG response and reply from the appellant and come back to give my view on that in terms of any further discussion or questions. And also, I think in the break, Mr Tucker, are you going to have a look at the Barnard's Drive decision and come back on any thoughts or?
If Ms Medley's colleague has managed to find it, it looks like they have, then yes, sir, we'll have a look at that over the break, as well as Ms Medley just looking and reminding herself of the context of the examination report. I don't anticipate that those will cause a problem, but we can do that within half an hour, sir. And in relation to the CCG information, our fairly firm submission is that you don't need to reopen that by way of a further roundtable discussion in respect of that, but that's of course a matter for you. If you decide that you do, sir, then Mr Hunter can be available later on today if you think that's useful.
Okay, well, what I'll suggest we do is we break for half an hour. I'll review the information, come back at 12, and if I do think there's a need for a discussion, then obviously we can adjourn again whilst the relevant people are sort of notified and brought into the meeting. So we'll do that, and when we come back, we'll obviously then cover any sort of final housekeeping for tomorrow, and any other procedural matters, unless there's anything else, Mr Tucker, you want to raise before we adjourn.
No, sir. Now that Mr Bevel has managed to find the two documents, sir, presumably you'll be happy for those just to be sent on to Malone and Friends team and the case officer, so they can be added as an inquiry documents anyway.
Yep, happy to have those both circulated. Thank you. Thank you. Mr Richards, anything from the council before we adjourn?
Just to say that some further documents have been added to the website. I'm not satisfied that they've been added with the correct numbers as you gave them this morning, so we'll tackle that over the break as well.
Fine. Well, we'll look at that and sort it out. So, yeah. Fine. Thank you. Well, if there's nothing from anybody else, we'll adjourn and we'll come back at. Oh, Councillor Astle, your hand's raised.
Yes, please. I just wonder, would there be any opportunity for us to give you an update on the neighbourhood plan progress at some point, please?
Sorry, update on, as in, presumably you're talking about a review of the neighbourhood plan?
Yes, the review, yes, of how we are with it.
It's something that really ought to, has there been any recent developments in the last few weeks? I'm conscious this inquiry has been running for a number of weeks now. Is there anything new that wasn't known about at the start of the inquiry?
Well, we've had our open event and the plan is ready for submission for SEA screening and the dates of when we're planning to go out to Reg 14 consultation. So we've got a bit clearer idea of the time frame.
Okay. Mr Tucker, any thoughts on me knowing that, receiving that?
I think you've just been told it, sir. The only thing you've not been told is the date. So it's difficult for me to invite you to do the American trick of striking something from the record and disregarding it. I don't object to Councillor Astle telling you when the Reg 14 is anticipated, presumably on the understanding that the plan's about to get a clean bill of health from the SA, which, as we sit here today, is probably unknowable. But I don't have any difficulty in you being told the final piece of the jigsaw, which is the date.
Okay, so yes, Councillor Astle, what is the date or the dates?
We're anticipating that it will go out to consultation, Reg 14 consultation in the middle of May, and we hope or aiming for submission to Charnwood, providing everything goes swimmingly, at the end of July, to the end of July.
Okay, and then presumably after that there would be an examination after it's submitted to Charnwood, and then they'll obviously do their checks, and there would be further consultation after that, wouldn't there?
Yes, we're advised that generally it takes about 6 months from submission or validation with the council to actual the plan being going to referendum and being made. So we'd be hoping January, February 2023.
Okay.
And there is a housing allocation as part of that plan.
Right. Okay. But obviously not this site, I would assume.
It has been assessed, but yes.
That sounded slightly flippant. I'm sorry. I assume it's not this site. Yeah. Fine. Okay. So, but there's just the one housing allocation.
At the moment, yes, that's what we're putting forward based on the need identified by Charnwood.
Okay. Thank you. Well, I've made a note of all that. So thank you for bringing that to my attention.
And so can I just add, obviously, you've got to treat with some degree of caution the additional information you've just been told, which is that there's need identified by Charnwood, which isn't before you, a draft allocation, which you don't know about. So I think we said I'm happy for you to receive the dates. The substance of what a document is that's not before us, I think you have to treat with a degree of caution. But subject to that, sir, no invitation for you to strike that from your memory.
Okay. Fine. Thank you. Thank you, Councillor Astor. Anything else?
No, I'll be quiet now. Thank you.
No, thank you. It's helpful. Thank you. Okay, let's break for half an hour. So we'll come back at 12 and pick things up then. So thanks. We'll adjourn till then.
Thank you, sir.
Thank you. Hello everyone, it's 12:05 and the inquiry is resumed. Thank you. So during the break, first of all, Mr. Tucker, did you have a chance to read or have sight of the Barnard's Drive decision, and is there anything you want to say about it?
Happy for you to receive it, sir. I'm not sure it takes matters very much further. From our perspective, the only point that we would make is it plainly deals with issues which transcend simply the settlement boundary and goes into issues such as CS1 and the approach of the sort of debate that Mr. Gould and I had yesterday. You will, of course, be cognizant when you read it that it's dealing with different arguments at a different point in time, and it doesn't appear that there was a 5-year land supply argument being put at that time. So subject to those caveats, which are, I'm sure, blindingly obvious when you read it, no difficulty at all in you receiving both documents, sir.
Okay, thank you. And obviously, yes, you've seen the examiner's report and you've already referred to that
Yes.
before the break. Fine. Well, as I said, I was happy to receive both of those documents. And if we say the Barnard's Drive decision is ID 23, I'm trying to keep up with all the numbering, and ID 24 is the examiner's report, or the extract from the examiner's report into the Sileby local neighbourhood plan, then they can both be added. I don't know if they've already been emailed around. I haven't seen anything during the break, but happy to receive those later on today.
So the full reports have been sent through, sir, but I think it's only paragraph 71 onwards that you need to have sight of in relation to the examiner's report. 71
to 78, I think you said.
That's right, sir, yes.
And I think it was paragraph 12 of the Barnard's Drive decision that was relevant to the limits to development.
Yes, sir. That's what's said to be relevant.
Yeah. Okay. Well, fine. Thank you. So, unless there's anything else to say about either of those two documents, I'm happy to leave it there.
Just to say, so yeah, we've got them too, and we will upload them with the numbers that you've got. We've also put in hand uploading ID 18 and 19 and 22, which are still missing off the website, but that's also in hand.
Okay. Yes, that's fine. We can double check things are there in the morning. And we'll have a conversation about the website and how long it needs to stay live for, etc. We can discuss that tomorrow morning.
Okay.
Thank you. And so, in terms of the CCG's letter from yesterday and the appellant's response, I've gone through that now during the break, and I think obviously there are 3 points that are being discussed in terms of factual points. They are in order. They are the double funding, the capacity issue, and the core hours or opening hours of the practice. And I think taking the second and third points, so the capacity and opening hours, I think fundamentally, as I read it, it comes down to a difference of opinion between the parties as to whether or not that is has a material effect on the need for a contribution. So I think really I'm just going to have to take a view on those 2 points as to whether or not I agree with one side or the other. I think both parties have made their points on capacity and opening hours, and I think I'm not sure there's any merit in debating those points or asking any questions on those points. On the double funding point, this one I've been sort of trying to get my head around, and I've obviously seen the CCG say that there is no double funding, that wouldn't occur, whereas the appellant says it would, or could rather occur. I guess I suppose I'm probably wondering, does the 106 prevent that from happening because it requires a covenant between the healthcare provider and the owner and borough council in terms of the spending the money, and if there's a covenant that says we shall spend this money on providing additional capacity at the 2 surgeries, is that sufficient to prevent any risk of the either GP practice seeking to get those costs reimbursed by the CCG or the NHS, or is the appellant's concerns of this sort of double funding still valid? And I appreciate I'm asking that question without Mr. Hunter present, so it may not be a question that can be answered immediately. But I suppose I'm still struggling with that point about double funding, having regard to what the 106 says. So I'm not sure we necessarily want to. Well, we may be able to deal with it now. Mr. Tucker, you may feel confident in responding to that without Mr. Hunter, but if you think you need him to be present, then I'm happy to adjourn and come back at a convenient time.
The answer to that, sir, is that Mr. Hunter has just popped up as a meeting guest. So okay. I think he's just been let in. So I was going to say that I think I know our response, but I'd prefer to have Mr. Hunter present to give that response. But I think Mr. Hunter is now here.
Yes. Hello, Mr. Hunter. Yeah.
Hello, sir. Yeah.
I see Mr. Shuttle was obviously on screen as well. So I don't know, Mr. Hunter may not have heard that. I assume so. I may need to say it again for his benefit. So, Mr. Hunter, we were just saying that obviously of the 3 factual points that have been raised by the CCG and that you've responded to, points 2 and 3, I say I don't have any questions on. I think there's a difference of view in terms of capacity and opening hours and how that materially affects or doesn't affect the need for a contribution. So I think I'm not going to ask you anything or Ms. Shuttlewood anything on that. On the first factual points about this issue of double funding, I've been trying to get my head around this and looking at what the 106 says. And sorry, before I go any further, I should have asked Ms Shuttlewood, have you seen a copy of the appellant's response? Yes, thank you. Sorry, I should have asked that at the outset, but I'll pause just to double check. Okay, so yes, in terms of the double funding concern, the 106 in schedule, the fourth schedule on page 40 says in terms of the healthcare contribution, that there would be a covenant between the healthcare provider, or a document from the healthcare provider covenanting to the owner and borough council that it will apply the contribution for the purposes of providing additional capacity at the two medical centres and for no other purpose. And if it's not been spent, then it would be refunded to the owner, or any unspent portion would be refunded. So my question is, does that give sufficient certainty that the money wouldn't be double funded, that either surgery wouldn't seek to try and reimburse in perhaps the way it might have done otherwise, or not? So that was my question. I don't. Mr. Tucker thought he knew the answer, but he also wanted Mr. Hunter to come in on that. So I don't know if, first of all, if the appellant wants to.
Well, it's probably better you hearing the answer from the organ grinder rather than the monkey. So I'll defer to Mr. Hunter, sir.
Okay, Mr. Hunter.
Thank you, sir. So the issue here is that if a planning obligation is utilised on expanding provision, which it very well may be utilised on expanding the size or the capacity of either of the GP surgeries, if that funding is then reimbursed through the process that can be applied, there is no clawback in the Section 106 to ensure that that money is then returned to the developer, and that is the ultimate inherent risk of double funding. So right. It's not a guarantee that it will happen, but it is definitely an option for the GP surgeries to be able to undertake that process to get the money back. But there is nothing in the Section 106 as a clawback mechanism for the developers to be refunded.
So that reference then to the healthcare provider covenanting to the owner and the borough council, that wouldn't prevent, in your view, it wouldn't prevent them or the individual practices rather seeking to reimburse the money.
No, I don't believe so. And so the clawback would be if the funding wasn't spent, but I think they would be able to demonstrate that money is actually being spent. What we wouldn't know, and there's no way for us to be able to ascertain, is whether that money is then reimbursed through the funding stream which is available to the surgeries.
Okay, that's the appellant's position.
Yes.
On this. Okay. Thank you, Ms. Shuttlewood. Anything you'd like to say in response?
Yes, I mean, for all the years I've worked in this arena, I've never ever known the double running in this scenario. So the CCG's raison d'etre is to ensure that there is best use of public funds. And we have the Section 106 agreement. We work very closely. The funding comes to the CCG. It doesn't go to practices. We work with the council and with the practices to ensure that appropriate usage of that money is undertaken. And there is no double running. We would give funding back if there is no use of that funding. But actually, that's very rare. We are under pressure all the time in health services in terms of capacity. The CCG doesn't receive capital funding to easily enable infrastructure. And we have to prioritise where there are developments to access as much of that funding as we possibly can. So I appreciate that the appellant is saying that there may be a possibility. I have never known it. I think there are plenty of checks and balances in place to avoid any potential of that happening. And the CCG manage the process, not the practices.
So, sorry, go on.
I'd also just like to say we haven't actually seen the Section 106 agreement. So, we would obviously clearly want to be cited on that when we were, if that proceeded.
Right. Okay. I mean, obviously the Borough Council have seen it and are happy with it, but appreciate the CCG haven't seen it. So just understand, Ms. Shuttlewood, so the money would go to the CCG. They would then would they then pass that on to the GP practices if they were doing their expansion works, or how would that money be spent?
So the practice would provide us with a business case of how that money would be used, and often it's used for to support the development. So, for example, a number of the scenarios that I've been working on, there is the practice of investing some money as well as the Section 106 supporting that development. And so depending on what was needed to be done, the business case would set that out. We would sign that off through one of our governance committees, and we would be clear on the revenue impact of any development, which the CCGs would then be required to support. After a period of time, there is an abatement to rent, depending on the agreement. So the CCG manages the process and works very closely with the councils, borough councils, etc., to ensure that that money is used as per the Section 106 governance agreement.
Okay. So in the event that a GP practice tried to, claim the money back, if you like, what would happen?
It's just not possible. They have to have a business case. We have to see that process, the developmental work through, and we are held to account in terms of demonstrating best use of that funding with regards to any development, any capacity developments within the practices.
Okay, thank you, Mr. Ruffle. I see Mr. Tucker has his hand raised. Would you like to come in, Mr. Tucker?
Yes, so just two things. Firstly, the terms of page 40 of the obligation that you have had sight of, sir, the finalised one, is in exactly the same terms as page 39 of core document ID 106, which has been on the council's public inquiry website for this inquiry since day 3 of the inquiry. So, sir, I obviously know that Ms Shuttlewood hasn't seen the 106, but it's been out there for a considerable period of time. Second thing, so this is a comparatively small point in relation to the overall issues, and I think we're probably happy to leave the point there. I would say that we take on board the general principle that public authorities can be assumed by a planning inspector, and indeed a local planning authority, that they would act in the public interest and responsibly. So it's really flagging up the fact that because the CCG can't be party to the 106, then there is no mechanism there, and it's a very small point in terms of the overall issues between the parties. So just those 2 points, sir, and I don't think there's much more that we need to say, although I know my learned friend's got his hand up as well.
Okay, well, thank you, Mr. Tucker. I'll let Mr. Richards come in.
Yes, sir, and I too would like to refer to page 40 of ID 18, which is the section 106.
Yes, I have that.
And paragraph 4 right at the bottom under the heading healthcare contribution. So the way this works is that the covenant to pay the healthcare contribution, unless it's blue penciled by you, is with the borough council.
Yes.
And so that the appellant covenants to pay the healthcare contribution to the healthcare provider, which is the CCG.
Yes.
So and this is the borough council's covenants.
Yes.
And a document from the healthcare provider, that's the CCG, covenanting to the owner and the borough council that it will apply the healthcare contribution for the purposes of providing additional capacity. And further, this is 4 lines from the bottom, if the healthcare contribution has not been expended for the defined purposes within a period of 5 years from the date of payment, the healthcare contribution to the healthcare provider by the borough's council to refund directly to the owner. In other words, before the borough council would pay any money to the CCG, the borough council, would ensure that there was a refund covenant in place.
Right, that's a refund for any unspent money.
Correct.
So it doesn't necessarily address the issue of the double funding or the reimbursement. But
no, it doesn't. But the mechanism is there is a mechanism for refunding money.
yes, I can see that.
Using the borough council as the clearing bank.
Yes, that's quite normal for a number of 106 countries.
It is.
Yeah,
That's the only thing I wanted to draw to your attention.
No, thank you for that. Anything else, Ms Shuttlewood? Anything you want to say? Anything further, or Mr. Hunter?
Not me, sir. Thank you. I think everything's covered in the documents provided, and I agree with everything that's been said so far.
Okay, thank you. That's great. I think it's helpful, particularly as I say, the other things. I think it's a sort of disagreement on, and it's for me to come to a view on that. I think the funding issue, it's helpful just to run through that, because I think it's a process obviously I'm not familiar with, and it's helpful to hear both parties' views on it. So thank you. That's all I wanted to say, but it's been helpful. So thank you to Ms Shuttlewood and Mr Hunter for joining us.
Thank you very much.
Thank you, sir.
Thank you. Okay, so I think that covers everything on that, and so all that's sort of left to do for today is really just, I don't think there's anything outstanding document-wise, apart from obviously I'll look out for the Barnard's Drive and the examiner's report, and hopefully the website will be updated with the documents in due course, and then so the intention then is for tomorrow morning we'll resume. I think we agreed at 10 o'clock to hear closing submissions of both parties. So Mr Richards will go first on behalf of the council, and then Mr Tucker for the appellant. If I can see, if I could have written copies of closings just before they're delivered. So Mr Richards, any time before 10, and then Mr Tucker, any time before you begin your delivery, and that would be helpful. So I can follow it both on screen and what you're saying at the same time.
Yes, so I completely trust my learner friend. So what we will do is we'll make sure that a copy of our closing is sent to my learner friend before the start of play, and also sent to you, so that gives you the opportunity to print it out. So I trust my learner friend not to start reading it until he's finished his closing.
Okay, that's fine. I'm glad that you can do that. That's good to know. Mr Richards, obviously you're happy with that.
Yeah, I'm happy with that, sir, and I will give the undertaking that Mr Tucker has so rightly expected of me.
Okay, thank you. That's good to know. Thank you. And therefore, anything else? Yes, we'll obviously hear those, and then at this stage, I suppose we might as well ask the question about cost applications. Obviously, there's an opportunity to still make a cost application. Are either party intending to do that?
No, sir.
No, sir.
I will check one more time after closing submissions, obviously, but just helpful to know for time management purposes. Thank you. So is there anything else that either party wants to raise before we adjourn? Anything else from Mr Tucker?
Not for our part, sir, and the WhatsApp isn't telling me to do so. And since I take my instructions now from WhatsApp, then that's the important point.
Okay, fine. Good to know. Thank you. Mr Richards?
And I'm just checking my WhatsApp. I have got messages, but not on this chat group.
Okay.
So thank you very much.
Okay, well, please don't read out the wrong message. That would be potentially unfortunate. So fine. Thank you both. We'll adjourn for today then, and we'll resume at 10 o'clock tomorrow, unless there's anything from anybody else in the meeting. But if not, we'll adjourn till 10. Okay, thank you. Goodbye.